Starting around 2015, folks at the Occupational Safety and Health Administration started to hear complaints about things going on at the psychiatric hospital located in Pembroke, Massachusetts. It was run by a company called UHS of Westwood, Pembroke. And the complaints were that inpatients in the psychiatric hospital were violently attacking members of the hospital staff. OSHA conducted an inspection and issued a citation under the General Duty Clause of the Occupational Safety and Health Act. The citation was also issued to a separate company, a management company named UHS of Delaware. An administrative law judge, hearing the matter, upheld the citation against UHS Pembroke, but it dismissed the matter as against UHS Delaware, the management company, on the belief that they did not form a single employer under the single employer doctrine. This went up to the Occupational Safety and Health Review Commission, and the Review Commission disagreed with the administrative law judge and found that the two entities did form a single employer under the single employer doctrine. The case has now been appealed to the U.S. Court of Appeals for the Third Circuit. We'll discuss this landmark case and what it means for the employer community. I'm Manesh Rath, and this is the December 21, 2022 episode of the OSHA 3030. Welcome, everyone, to the OSHA 3030. I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman, right here in Washington, D.C., and I have represented employers in the field of occupational safety and health law for just about all of my 26 or more years of practice. And I'm very fortunate today because I'm joined by my dear friend and my colleague here at Keller and Heckman, Taylor Johnson. Taylor, welcome to the OSHA 3030.
Thanks for having me, Manesh. It's a pleasure as always.
Yeah, and we have a good topic. But this is a topic we've covered in a prior episode of the OSHA 3030, back when it was a decision issued before it got appealed to the Third Circuit. And now We're covering the appeal itself. So we're going to have another episode someday in the future when the Third Circuit issues an opinion on this, perhaps in May or June. It wouldn't surprise me. And so, because I think this is of such importance to the employer community. So Taylor, why don't we get right into it and talk about what we're going to talk about today?
Sure. So we're going to start with just reviewing the corporate structure of UHS, Universal Health Services. It's going to be really important to kind of understand the layers to that structure as we go through the case. And then we're going to get into the background of the investigation and then the subsequent citation.
Yeah, I think that's a good way to start. And then we'll analyze the Review Commission's decision. And most importantly, we're going to talk about what the two parties, UHS and the Occupational Safety and Health Administration, argued in their briefs to the Third Circuit, so that we can understand how both of them believe this case should come out at the Third Circuit.
Right. And then we'll discuss the single employer doctrine, really break that down. That's sort of the key issue here in the case. And then, as always, we'll wrap up with practical takeaway action items for employers to bring back to their workplace.
Right. And Taylor, as you know, this is a live webinar that we record and publish as a podcast. And so for the live audience here on December 21, 2022, we will turn off all the recordings after the program is done and stick around and go off the record. People can use the question and answer function and post any questions they want. We've had a couple that have been pre-submitted. We'll take a look at those and answer any questions remaining from the live audience in the off the record section. Again, only for the live audience. For the podcast and for republishing it on YouTube, that section will not be included because it's supposed to just be an informal chat amongst community members here at the OSHA 3030. So with that said, let's get into it. Corporate structure at UHS. Taylor?
Yeah, so Universal Health Services, UHS, owns both Westford Pembroke Hospital and UHS of Delaware Incorporated. And then below UHS of Westford Pembroke, so they own and operate three entities: Pembroke Hospital, Westwood Lodge, and then the Lowell Treatment Center. And while each facility is located as a separate at a separate address, collectively the sites share a license and we're a single business entity. And then, Manesh, there's UHS of Delaware, which essentially serves as a management company.
Yeah, that's important, Taylor, because this management company is a third party, completely separately incorporated entity. And what it's basically doing is it's hiring a lot of the staff and leasing them back out to these other
Right.
two entities. And it's handling a lot of the management functions on a fee basis. Why is that important? Because this fee basis management services is something that establishes that they are arm's length, distinct entities, even though they are going to be working cooperatively together. Of course, there's some common interest and common elements of ownership. But so I don't mean to imply otherwise in use of the term arm's length, but merely that on the exchange of fees for this management service, that would be in that regard similar to other truly distant and fully unrelated management services companies. So an interesting setup, but not at all uncommon. And many of our clients have
Right.
not only incorporated subsidiaries, but they've also incorporated another subsidiary who handles management services or employment services for some of the other subsidiaries. That is a very common method of organizing an umbrella corporate entity. And it's also common to separately incorporate entities by state as well, particularly in enterprises that are in state regulated sort of activities. So OSHA conducts an investigation, and on the basis of these complaints that it's been receiving, several instances where patients have attacked staff members, some of them rather severe acts of violence.
Exactly. 32 injuries were attributable to patient violence during the 2 years before the citation. And so there were inspections that occurred in 2015, 2016, new complaints in 2017. OSHA had actually previously inspected Pembroke Hospital before this citation that's the subject of today's case. A letter was issued with potential abatements, but no specific action was taken. No citation was issued, and the general duty clause was not involved at that time. But then OSHA did issue a citation under the general duty clause to UHS Pembroke and importantly, UHS Delaware.
Right. And there was a couple of complaints, another complaint on March 27th, 2017. This idea that there was a citation previously issued under the general duty clause at UHS's Lowell Treatment Center is one of the facts that the parties debate as to whether it's relevant. And indeed, OSHA amended its citation to call it a repeat on the basis of that Lowell Treatment Center citation earlier, although the forms of abatement that it recommended were not overlapping significantly. There were a completely different set of abatement proposals in each case. And as you know, these acts of patient violence are oftentimes inherently unpredictable and sometimes inherently unique on a per patient basis. So they issued a citation under the general duty clause. Taylor, we've talked about the general duty clause in many episodes of the OSHA 3030, but I think it's helpful for the members of the OSHA 3030 community attending this program if we just walk them through real quickly an overview of what that means.
Sure. So in order to prove a violation of the general duty clause, there are 4 key elements that we always talk about. The first is that a hazard existed. Important to start, by the way, that the secretary, so OSHA, must prove that these 4 elements existed. The burden falls on them. 1, that a hazard existed. 2, that the employer knew of the hazard. 3, that the hazard caused death or serious harm. And then 4, that a feasible means of abatement existed. And so those are sort of the 4 elements that we go through when we talk about the general duty clause.
Right. And to clarify, not that it caused death or serious harm, but that it was a kind of hazard that is capable of causing death or serious harm. Right.
Yes.
Yeah. And I think those 4 elements, it's also important to remember that OSHA has to prove all of those 4 elements. And if they can establish really concretely 3 of them, but fail to establish a 4th one, then they have failed to establish a general duty clause. It is, in that sense, a harder type of citation for OSHA to establish than to prove a violation of a specific duly promulgated OSHA standard. And so this idea that knowledge of a hazard is something that OSHA has to establish really goes to the idea that either that specific hazard or that type of hazard was either known by that employer or was generally recognized by the industry in which that employer sits, is the multiple ways in which OSHA can prove that element. So we have a citation under the general duty clause, and OSHA brings it not only against UHS Pembroke, but also against the management company, UHS Delaware. Taylor, why did they think that they could bring a case against the management company? What were the 2 or 3 facts that they alleged that suggest that they thought that this was appropriate?
Sure. So the first one, and this is heavily debated sort of at each stage in this case, is whether or not UHS Delaware and UHS Pembroke shared a common work site. But OSHA and then the ALJ eventually, as we'll get to, sort of agrees that this is the case, that they do share a common work site. UHS sort of pushes back on this, arguing that that the work site may be shared, but that their employees were not exposed to a common hazard, so that the hazards that the employees at UHS Pembroke were being exposed to were not the same, was not being exposed to the UHS Delaware employees. And so that's the sort of the first step, is share a common work site. OSHA also says that operations were sort of interrelated and integrated between UHS Pembroke and UHS Delaware. And then the third one is sharing a common president, management, or supervision or ownership.
Yeah, and that disjunctive "or" means that OSHA can establish that there is a common leadership or a common management or a common supervision or a common ownership to show interrelatedness. I think that this is an interesting set of elements for establishing that 2 incorporated entities may actually be a single employer for the purpose of compliance with OSHA standards. This idea that they share a common work site, UHS, as you stated, pushed back, and they pointed to a decision from the U.S. Court of Appeals in the First Circuit. A.C. Castle was the name of the case, and in that case, the First Circuit Court of Appeals said that the agency has to establish that the 2 entities share a common work site, which requires, as part of that showing, that there was consideration of not only the location, but also where the common location where employees from both entities worked, but also that the employees from both entities were both exposed to a common worksite hazard, the worksite hazard being alleged in the general duty clause. And that A.C. Castle case is really going to form the basis of the test for the Third Circuit, whether or not they want to adopt the First Circuit decision or create a circuit court split on this question is really one of the central issues before the Third Circuit in this matter. I think it makes it of incredible value and importance to the employer community. And frankly, anytime you see a circuit split, it's exceptionally rare, and it's of great import to employers. Okay, so UHS Pembroke and UHS Delaware argued that they have different work sites. UHS Delaware is headquartered in Delaware, and Pembroke is in Pembroke, Massachusetts, and that no UHS Delaware employees were exposed to the hazard. So there's a couple of employees, at least, at the Pembroke, Massachusetts worksite who were actually formally employed by UHS Delaware. And that's important because they do share a common establishment in that sense, that there are at least a couple of employees. The manager of the facility is formally employed by UHS Delaware, even though he's working at UHS Pembroke, and one other employee at least. So they do work at the same establishment as employees of UHS Pembroke. However, as UHS argues, those Delaware employees were not exposed to any of the alleged hazards in this case. They were in a completely different part of the establishment and didn't share the work site where the hazard occurred. For example, patient treatment rooms or their residential rooms.
That's right. And the ALJ accepts this argument by UHS and concludes on this point that the 2 entities did not share a common workplace. Then moving on to sort of the second prong of the analysis, the ALJ finds that although UHS Delaware and UHS Pembroke sort of had related businesses, they were distinct. That sort of one in patient care, obviously, that being Pembroke, and then the other one, Delaware, being in management and consulting. That the sort of the distinction between those two, the ALJ found was enough to say that they did not meet the sort of relatedness, commingled prong, the second prong of the analysis.
Right. And finally, the administrative law judge found that there wasn't any daily oversight by UHS Delaware, although one of their staff, one of their formally employed staff was the manager of the Pembroke facility. That wasn't a case of UHS Delaware managing UHS Pembroke. It was a leased employee who was sent over for the purpose of working for UHS Pembroke. And they maintained these two entities, their own management structure and separate corporate leadership. So now this comes to the review commission under the single employer doctrine, and the review commission disagrees almost across the board, Taylor, with the administrative law judge.
That's exactly right. They do on every prong. So starting with the first one, the common work site, the review commission finds that the Delaware employees were sort of on site on a daily basis at the Pembroke facility, and that was enough to meet the common work site prong. That mutual access to a hazard in the eyes of the review commission is not a prerequisite to fulfilling this common work site prong of the analysis.
Right. And they found that the direct supervision element was met when OSHA established evidence that UHS Delaware's staff provided policy development and managed the finances, et cetera. They also found that on that third prong, that Pembroke's CEO and CFO, these two employees I was referring to, who were formerly employed by UHS Delaware and located at UHS Pembroke, were integrally involved in the day-to-day management of that establishment in Pembroke. Well, as I said before, the way I saw that was that they were formally employed by UHS Delaware, but they were essentially leased to UHS Pembroke or assigned over there to serve UHS Pembroke, not to serve as an agent of UHS Delaware. That difference, I hope, is the difference that's getting tested by the Third Circuit.
So next, just one part of the case, just to unpack here further, is just the characterization of the citation. So at the ALJ level, the ALJ actually finds that the citation was not a repeat citation. He sort of unpacks the differences between the prior citation that happened at the Lowell facility and then the citation that occurred that was handed out in relation to conduct at the Pembroke facility. But the review commission also disagrees with this aspect of the case, affirms the citation as a repeat, essentially says that the incidents at Pembroke and Lowell involved employees exposed to almost an identical hazard, and so that's why they established the citation as serious or as repeat.
Yeah, this is interesting. And so in regards to the question of whether it's a repeat, you see the review commission disagreeing with the administrative law judge, not just on the question of the single employer test or any of the three elements. They seem to have disagreed with the administrative law judge on all of them. This commission now is currently composed, and this opinion was written by a two-person review commission. A fully staffed review commission would be 3 commissioners. Right now, 1 seat's vacant. This was an opinion penned by 2 commissioners who were appointed by opposing parties. Commissioner Lehau, who has been a guest here on the OSHA 3030 in the past, as was one of her predecessors, Commissioner Sullivan. And the other is Commissioner Atwood, who is a long-serving and very thoughtful commissioner for the Occupational Safety and Health Review Commission, who we would love to have as a guest maybe someday in the future. And they seem to have agreed on all of these elements and collectively agreed to disagree with the administrative law judge. So now this has been appealed to the Third Circuit, the U.S. Court of Appeals for the Third Circuit, and UHS Delaware and UHS Pembroke have appealed the review commission decision, saying this idea that these two entities that have carefully maintained their separateness should be treated as a single employer for the purpose of OSHA citations would constitute a dramatic shift in the existing law. They are relying on the decision in AC Castle, for example, decided in the First Circuit. And they believe that it's one thing for the courts to grant agency deference to the commission or to OSHA. That's something that we recognize as a established principle of legislative interpretation. The regulatory interpretation in this case, that an agency should be granted deference. However, UHS argues that deference should not be granted when it constitutes a dramatic shift in existing law, and that shift is arbitrary and capricious, as UHS asserts is the case here. OSHA, by contrast, has argued that the Review Commission is following existing doctrine, and that fundamentally the divide, Taylor, seems to be drawn on whether or not a common establishment or a common work site doctrine includes the definition of a common hazard at that work site that both entities' employees were exposed to.
Right, exactly. Whether or not that exposure element needs to be shared amongst the entity, the employees of the two entities, I think is really going to be interesting to see where the Third Circuit comes down here. And also, so they're going to rule on that issue as well, which is what we're all waiting to see what happens with the single employer issue. And then also, as we mentioned, the characterization of the citation will also be something that the Third Circuit will rule on, whether or not this citation that happened at the Lowell facility is sort of related enough to what happened at Pembroke to where this could be a repeat citation. So that's another sort of issue that'll be interesting to see where the Third Circuit comes down.
Yeah, Taylor, that's really an outgrowth of the single employer entity doctrine too, when you think about it, because
Right.
the Lowell Treatment Center was incorporated separately from the Pembroke Hospital. And so to treat the citation against one as the predicate for a repeat citation to the second entity really requires that you treat them as a single employer in a sense. So another interesting manifestation of the impact of the single employer doctrine is not only whether you can cite two entities, a management company and a independently operating sister subsidiary, but also whether or not two separate incorporated subsidiaries can be treated as one. We handled another case at the OSHA 3030 involving Loretto Oswego, which is another series of healthcare facilities up in upstate New York. And that case was discussed here in this opinion and will form part of the discussion, I think, with the Third Circuit as to what the established doctrine of law that the agency and the Review Commission had been operating under all this time. So that's the Third Circuit Court of Appeals. What should employers do in light of the UHS case? Well, right now it's being appealed. So I think the first thing to say is to watch this channel. We'll cover the decision when it gets issued by the Third Circuit, and to keep an eye on this case.
Yeah, absolutely. And the next one that kind of really jumped off to us here is OSHA's failure to issue a citation in a prior inspection may not be an effective defense if you're cited again. You see UHS try to make this argument before the ALJ that OSHA had already been out to the facility, had already inspected it based on complaints of patient aggression, and they chose not to issue a citation. And so they tried to lean on that in their defense, and the ALJ dismisses that as sort of not being an effective defense that you can make. And just because you weren't cited before for something doesn't mean that you can't be cited for it down the road.
Right, but there is something inherently unique about each case of patient violence against the staff.
Sure.
Every patient case is different. And so I think that their point was well taken, that the suggestions that were offered in the past by OSHA, many of which UHS embraced and implemented, also forms a defense that, if the last time you came, you made these following suggestions, some of which work, some of them don't, but we implemented some of them that we thought would work. That is not only proof that this is not well suited for the general duty clause because it requires that there be generally accepted hazards, but also it's proof that OSHA didn't have any clear recipe for how to eliminate workplace inpatient violence in the healthcare setting, in the psychiatric inpatient setting. So another, I think, takeaway item from this case is that citations that are issued to sister subsidiaries or related entities theoretically OSHA has taken the position that it could lead to classifying a subsequent citation as a repeat. Again, there seems to be a number of decisions that have gone in different directions, and they're fact dependent. So this case will ultimately, hopefully, shed more light or clarity on how employers should treat that question.
Right. The next is that control by a management company over day-to-day operations, over finances, can certainly lead to a single employer determination. I know we'll see again where the Third Circuit ultimately comes out on this, but you see the review commission looking at these facts by that the management company had this sort of day-to-day control over what went on in the facility and finances, and found that to be enough to link the entities as a single employer for purposes of assigning liability.
I think another takeaway item from this case is that management companies' employees should be contractually delineated as to what their duties are, and that it should contractually state that these management company employees are being leased out to the other subsidiary to serve the other subsidiary, not the management company.
Right. Another is that a management company should have defined powers with respect to operational decisions. So, we didn't exactly see this happen in the facts of this case, which may have been one of the reasons why, the review commission decided the way that it did. That, clearly, sort of boxed in powers, clearly defined roles, if they will have, control over operational decisions, can certainly help make the argument that these are two, distinct entities.
And that middle element for the single employer test about common policies really indicates to me the value of taking these system-wide procedures for safety and health and republishing them at the entity level so that they all have their own distinct versions of safety procedures, so that they can't, this one document that's shared across all entities can't be used against one of the subsidiaries. Okay, well, those are some of the takeaway items, but I think the chief takeaway item here is to keep an eye out on this case and see how the Third Circuit decides it. We think that we'll see a decision sometime between now and June. We'll cover it again in another episode of the OSHA 3030, because this idea of multiple sister subsidiaries being treated as one in defiance of the corporate purpose of separately incorporating them is one of incredible significance to the employer community. With that said, that's the OSHA 3030. Remember, all of our prior episodes, and we've been doing this for almost 10 years, are on our website, khlaw.com/OSHA 3030. There's easily 110 episodes, all of which are still relevant to this day. So check them out and poke through the library and find some old episodes, play them on your YouTube player, I believe is how they're linked through, and they're self-executing videos and audio. We'll be back again in another month. The OSHA 3030, in the meantime, is available. This episode will be published on YouTube. Both Taylor Johnson and I are on LinkedIn. I hope you send us invitations to LinkedIn so that we can stay in touch. Please remember to forward an invitation to the next OSHA 3030 to at least 3 other people, in-house counsel and safety and health professionals at your organization or at other organizations, so that we can keep the program alive. And this program will also be on podcast. Remember to subscribe, and also, if you can, rate or like the podcast so that others can find it more easily. Our next episode will come back again at 1 p.m. Eastern time on January 25th, 2023. Always at 1 p.m. Eastern and always on a Wednesday. We look forward to seeing you then. Our sister programs, the TSCA 3030, Reach 3030, are coming back in January on the 11th and February the 8th, respectively. So please stay tuned if your organization is responsible for compliance with those statutes. Until we see you again next month, please stick around for the off the record section if you have another few minutes. And until we see you again next month, on behalf of Keller and Heckman and my colleague Taylor Johnson and myself, thank you all for attending this OSHA 3030. And until next month, stay safe.